There's the commercial or the business aspect of a law like this and the money, but let's not forget, it really is about worker safety. I always recall, and I tell the story of a project I was on about 10 years ago when I was in the field and I looked up at an electrician that was on a piece of scaffolding, and the manner in which that individual was working was not safe. So I called out and said, hey, where's your harness? You should be strapped in and you should be protected. And the response was, hey, if I fall, I'm a rich man. And that always resonates back with me, because if that's the mindset of the worker out there, what if that person falls and there is no tomorrow? How sad is that? Turner Construction is a 110-year-old construction company founded in New York. We have 5,000 employees in the United States and an international worldwide. We are the largest volume construction manager in E&R for past several years now in terms of construction and commercial management. Do I think the scaffold law in New York State is fair? Absolutely not. When you have no defense whatsoever and you're 100% liable for what they do, no matter what you can do, that's totally unfair. Turner Construction has always been on the forefront of safety in terms of changing the safety culture within the construction industry, and that has really grown over the past, at least in my 25 years of construction. I mean, safety is paramount now. Turner Construction was the first company in upstate New York to be a star classification in the voluntary protection program under OSHA. We invite OSHA into our world to just look at and inspect us and look at our program, and we qualified for this based on how we approach safety and our proactiveness to safety. So we were the first one, and we're pretty proud about that program and having that status under OSHA. The effect the labor law has had on Turner Construction's insurance rates: in 2012 we saw a 25% increase in our GL rates, and in 2013 we saw another 18% increase in our general liability rates. When you look at it, there are construction budgets for every project that's out there, and those budgets are consumed by the components of the construction, and you can spend money on a number of areas. Well, when a higher component of yours is going to insurance rates, it's going to less brick and mortar in the field, which translates into less jobs and less construction that is built. With the scaffold law, the GCs are the #1 target. So has Turner been sued under the scaffold law? Yes, we have. We have, and the effect it is we now as a defendant have to go and hire counsel, and we have to take time and resources to defend ourselves in a situation that we've really done nothing wrong. And there's a case in point where there was a particular case where a worker went out of the dumpster and grabbed a ladder that was deemed unsafe, used that ladder to access the roof, fell and was hurt, and had a very sizable award based on that incident, and knew well that that ladder was not safe, but yet Turner was held liable for that. Turner had to pay out on that claim, and there was nothing we could do to defend ourselves, even though that worker knew that ladder was not safe. We're not advocating for a construction company not being liable if they force somebody to do something unsafe or cause someone harm, and I think that's the misconception. That's not it. If that is the case, then that company should be held liable. We're simply asking for the ability to defend ourselves. Should we do everything correctly, we educate that worker, we provide all of those components, the safety, everything that's required to work safely to that worker, yet they're recalcitrant and they don't want to respond to that and they don't want to follow the rules, and we want to have a defense for that.